Hey everyone, and welcome to This Explainer. Today, we're unpacking a topic that affects almost every single family in Ontario, and yet it is wildly misunderstood. We're talking about estate planning for 2026, and we're going to uncover a pretty dangerous misconception. You see, most people think that drafting a standard last will and testament is this ultimate, bulletproof safeguard for their legacy. It's the whole shebang, right? Well, what if I told you that your will actually controls a lot less of your money than you think?
But real quick, before we get into all those details, I just need to mention something up front. Olenor is an AI lawyer matching platform. We are not a law firm. So while we're definitely diving deep into some fascinating legal facts today, this explainer is strictly educational. It doesn't provide legal advice or legal guides, and it's absolutely not a substitute for professional legal counsel. You always want to consult a professional for your own specific situation.
Okay, let's dive into this. Imagine a father from Mississauga who passes away. He leaves behind this perfectly tidy, totally legally sound will, leaving absolutely everything to his two daughters. Sounds pretty cut and dry, right? But he had an RRSP, and on that specific account, he had signed a simple bank slip way back in 1998 naming his first wife as the beneficiary. So who do you think gets the RRSP? The ex-wife. That outdated, decades-old piece of paper completely bypassed his meticulously drafted will.
When we actually look at the numbers, it becomes painfully clear just how much wealth sits totally outside the control of a will. Think about a recent 2023 survey of older Ontario households. Out of roughly $2.69 trillion in assets, the will actually dictates the fate of only 31.7%. That leaves a massive 68.3% of wealth, we're talking about employer pensions, RRSPs, jointly held real estate, dictated entirely by beneficiary designations and title registrations. That unseen 68%, that is the real threat to an estate plan.
So what does this all mean? Well, it means we need to completely flip our mental model upside down. We all tend to think of the will as the absolute boss of our estate. But in reality, under Ontario law, the will is just what's called a residual instrument. It actually sits at the very bottom of the inheritance hierarchy. It literally just catches whatever nothing else is claimed. If an asset has a living named beneficiary, or if it passes by survivorship, it's already gone before the executor even starts reading the will.
Why does this happen? It's because those beneficiary designations are paid first, and they ask absolutely no questions. A quickly scribbled designation form on an RRSP or TFSA is a direct contract with your financial institution. It completely outranks a $900 will drafted by a fancy law firm. And here's the kicker. Putting a general line in your will that says something like, "I revoke all prior dispositions," does absolutely nothing to change that bank form. The newest form on file wins, period.
But wait, the hierarchy gets even more complex, because even a named beneficiary isn't always at the absolute top of the ladder. If you have an Ontario-registered workplace pension, provincial law, specifically Section 48 of the Pension Benefits Act, creates a strict, unbreakable hierarchy. Step 1 is the surviving spouse. Step 2 is the designated beneficiary. Step 3 is the estate. So, if you pass away before retirement, the law actually hands that death benefit to your surviving spouse first, completely overriding whoever you designated on the form, unless of course you were legally separated.
Which brings us to another massive chunk of that wealth pie, real estate and bank accounts. A question we hear all the time is, hey, does putting the house in joint names with an adult child avoid probate? It is a super common do-it-yourself estate planning tactic to try and bypass the will and save on the estate administration tax. But doing this can trigger a whole new set of severe problems that families only end up discovering when it's way too late.
To understand why, we have to look at the difference between a true gift and an arrangement made just for convenience. Because of a Supreme Court decision known as PECOR, adding a child to a property title isn't automatically seen as a genuine gift that immediately passes to them. Because the courts really want to protect seniors, the law actually presumes the child is just holding that property in a resulting trust for the parent's estate. It is entirely up to the adult child to legally prove you intended it as a gift. And if they can't, you risk messy sibling litigation and the asset falls right back into the estate anyway.
Now, what if you intentionally try to leave someone out? Say you have a spouse, a common law partner, or a child that you financially support, but you decide to leave them nothing. Well, under Section 72 of Ontario law, a dependent's claim can reach right past your will. A judge has the power to legally claw back joint accounts, jointly held property, life insurance payouts, RSED designations, and even gifts made before death. They pull all these supposedly protected assets back into a notional estate to ensure that dependent gets the financial support they're owed.
And this brilliantly illustrates how life events can silently rewrite your estate plan without you even knowing. Since January 1, 2022, Ontario law shifted significantly. Getting married no longer revokes an existing will, but a qualifying separation now effectively edits it, treating your ex-spouse as if they died first, which cancels their gifts. However, here's the truly terrifying part. While a separation legally edits the will, it leaves your beneficiary designation forms on your RRSPs and life insurance completely untouched.
Beyond just the money, these rules deeply impact your family. If you have minor children, you likely named a guardian for them in your will. But think about the number 90. That is exactly how many days that appointment actually lasts. The guardian you name in your will only holds that legal authority for 90 days. Unless they formally apply to the court within that window to make it permanent, the appointment just expires. So it's really more of a short-term nomination with a very strict deadline.
Actually, scratch that. There's a massive blind spot in everything we've covered so far. It all assumes you have passed away. A will does absolutely nothing for you while you are alive. All of these death documents, the will, the designations, the survivorships, they are completely useless if you suffer a medical emergency or lose capacity while you are still living. If you skip drafting a power of attorney for personal care, you don't get to choose who makes your medical decisions. Instead, Ontario forces a rigid, ranked statutory list to dictate your treatment. It goes from spouses down to children, parents, and then siblings. And if two people in the same rank, say, two of your adult siblings disagree on your treatment, they don't get a tiebreaker vote. The law automatically hands the decision over to the public guardian and trustee. That means a government office you've literally never met is suddenly making your most intimate health decisions.
Okay, I know this might feel like a lot to take in. You might be feeling a bit of anxiety right now, wondering if your own paperwork is secretly working against you. So the natural question is, how do you fix your estate plan? How do you actually ensure that your designations, your joint property titles, and your will all align properly and execute your true wishes?
Well, the absolute best way is to get a professional to look at the entire stack of your documents, not just fill out a basic will template. And you can do this incredibly easily by using Olanor.com. Olanor provides a 100% free matching process that pairs you with verified wills and estates lawyers right here in Ontario. In just minutes, you can find the exact right lawyer who will review all your documents, your designations, your property registrations, and your will, and get quotes for a full stack review to ensure everything is perfectly in sync. So, I want to leave you with this final, provocative thought. Before the next form you casually sign at a bank counter, or the next time you think your standard will has you fully covered, ask yourself, who is really inheriting your legacy? Take the time to list out your accounts, check those beneficiary designations, and seriously, book a legal review. Thank you so much for joining me for this explainer, and I really hope this empowers you to take full control of your planning.